questions to raise or have any problems during the session, please let Isabel know and she'll pick them up for you. Can I just check with everyone if you can give me a thumbs up that you can hear me okay and that you can see the slides on the screen?
I can hear.
Brilliant. Thanks, Iz. Thank you, everyone. Okay, and we're recording, are we, Isabel? Thank you.
Yep, recording started.
Lovely. Thank you very much. Okay, let's get started. So by the end of the session today, you should have an understanding or basic understanding of what copyright is and its importance to your work. You'll have gained some knowledge about Creative Commons and where to find open access content. And you will be able to seek permission from copyright holders using the documents and tips we provide you with. And we'll also go over a couple of scenarios to show you some common sense approaches to sharing your work and why some situations may require a higher risk copyright decision to be made. And if we have time at the end of the session, we'll answer any questions you have. And if you have any very specific queries that need a deeper investigation, then we're always happy to help and you can contact us about that. So firstly, we'll take a look at what copyright is and why you need to think about it. So it is likely that you're going to want to use content in your presentations that has not been created by you. And we refer to this as third-party content. So thinking about this early on in your process will make it much more simple for you. So before we begin, I just want to run a little poll, if I can, just to get an idea of how you feel about copyright. Let me see if I can bring this up for you. Can everyone see that poll on the screen there?
Yeah, we can see it.
Brilliant. Just a couple of moments just to let me know how you feel about it at this moment in time. That's good. Everyone's mostly fairly confident. That's good news. A couple of people not confident and scary copyright. Yeah, well, we've just had Halloween, so that's fine. I'm sure it will be less scary by the time we get through this and when you see that copyright can be thought of in a very straightforward, logical way. So hopefully that will put your mind at ease. So thank you for that. Thanks for doing that. Let's get rid of that. Okay. So first off, we have a list here, and you can see that copyright is just one type of intellectual property right that protects a creation. So some creative works require a combination of intellectual property rights to protect it. So if you think of an example like a car design, perhaps. So the purpose of today's session is just copyright, but I should point out that moral rights will also be considered here today, and that's something that you should also consider when using third-party copyrighted material, and I'll go on to that a little bit later. Once an idea has been fixed, such as a book or a film, for instance, copyright protection is automatically applied, so there is no formal way to register your creation. The CDPA, the Copyright Designs and Patents Act of 1988, is the legal act that protects the fixed expression of ideas. And in order to be protected by copyright legislation, your work must be original and created by you. The quality of the work is not considered here, that's not important, but it has to be original. The creator has an exclusive right to disseminate their original work how they wish, and they can choose how the general public may perform it, license, copy, lend, and communicate their work. However, this right can be contractually reassigned to another person or company. For instance, anything I create during my employment with the OU belongs to the OU and not to me. The types of creative output covered by copyright legislation are listed here. As you can see, it covers pretty much everything you can think of, and these are all covered by the CDPA of 1988, and in some cases have been defined as a result of legal actions. If you're interested in copyright infringement cases, you never know, you might be, you can search for the recent Led Zeppelin Stairway to Heaven dispute, for instance. Or in the case of trademarks, there was a recent incident with Banksy and greetings cards. So there are some interesting cases out there for you to have a look at. A work can potentially have many layers of copyright protection. And an example of this could be a co-produced BBC OU TV programme. So this may include images or stills, music, archived footage, sound recordings, literary or artistic works, and all of which the BBC would need to seek permission to use, potentially from multiple copyright holders. So as you can imagine, it can be an expensive affair. The duration of copyright varies, and depending upon the type of work, as you can see here, it's important to note that different countries have different approaches to copyright law. The protections listed here refer only to the UK. And once the copyright protection expires, the work generally moves on to the public domain. The term public domain can refer to works that are out of copyright, but some caution must be taken. For instance, under the copyright law in the USA, some federal government content is classified as public domain, and you wouldn't necessarily need to credit it or acknowledge it. But in the UK, that public domain declaration wouldn't apply. It's not viewed in the same way under the UK law. So we may use it as a public domain work, but we would need to still credit or acknowledge it if we're going to use it. As you can see here, most things you may be looking at for your work would probably be under the literary, dramatic, artistic works, i.e. images and so on, or books or things like that. So you are looking at 70 years after the death of the creator. And if in the case of films where you have several different people involved, it would be the 70 years after the last person to die before it would then lose its copyright protection. If you decide to use third-party content in your presentations, it is your responsibility to make sure you have the appropriate level of permissions in place. I know that copyright concerns are unlikely to be at the top of anyone's list of priorities when researching and preparing for your conference or workshop, but if you do decide to include any third-party content, it is worth taking a moment just to reflect a little on what you're using and why you're using it. And this is why we would suggest using Creative Commons licensed content or other similarly licensed content if you can. It's highly likely that you'll have heard of Creative Commons already. I'm sure most of you have, and you may already know a little bit about how it works. However, I will explain further in a moment about CC content and why it is a good idea. But there may be occasions where CC content is just not feasible. So perhaps you need something very specific that just can't be found anywhere licensed in that way. An image from a book, perhaps, a particular scientific diagram or image, or a video from YouTube. You may need to seek formal permission from the rights holder of the content, and this can present some challenges and can potentially take some time to achieve. So it's important to be very realistic and factor in this extra time and to be prepared to find an alternative if the original one you want doesn't quite work out. So before we move on to Creative Commons, does anybody have any questions at all before we move on? Right, Paul, I can see your question there. What counts as a presentation? In the context of this training session, I'm thinking of presentations that you may do in person or online in workshops, conferences and such like. So PowerPoint presentations, even presentations using non-electronic means to students would be an exemption, wouldn't it? I'll come to that a little bit later on, because what you're referring to is more educational use. So if you were to be, and it would depend on your audience about what you can use. So I will come to that a little bit later on, if that's okay. The question there, does academic publication copyright belong to authors or their organisations? That would very much depend on what the publication terms and conditions are, and they do vary. It's not going to be a blanket decision one way or the other. So if you are unsure, I would make sure you double check the terms and conditions of any paperwork you sign, any contracts you enter when you go into workshops and conferences and things like that. I hope I can gather all the questions. I might just answer one more and then perhaps have a look at some at the end, if that's okay. Let's see. Can you use small excerpts of, for example, a song without needing to get approval? That's just a few seconds of a song. That's a very good question. And it would depend on what part. It's not a straightforward answer, unfortunately. It would depend very much on the part of the song that you're using. If it was something very like a famous part of a chorus, for instance, that would probably be deemed as pretty substantial and something you would need to get approval for. If it was something you're trying to sort of showcase, like I don't know, a chord progression or something like that, there are other ways to do it rather than playing the song through YouTube or such like. So there are ways around it, but yes, with things like music, things like poetry, there might be very small pieces to our mind, you know, just a couple of lines or a minute or something, but they would really be quite substantial. So it's something that you need to be quite cautious and aware of. Are you okay to capture some of the other questions, Isabel, if that's okay? And then we'll have a look later on.
And then we'll have a look at the end. Yeah, that's fine.
Brilliant. Thank you. Thanks, everyone. So we'll just go on to Creative Commons now. As I mentioned earlier, I'm sure most of you are aware of Creative Commons, or at least have seen it on websites. So I'll go through this and hopefully you'll have a better idea. The important points of Creative Commons are listed here for you. It's an internationally recognised and legal licence to protect the work and its creator by giving them control over how they'd like it to be reused. So the idea is that you must always follow the terms of the licence of whatever you use, and that you credit or attribute the rights holder, providing a link not only to the source of where you found the image, artwork, or whatever it might be, but also to the Creative Commons licence itself, to prove and to show that you are using it in a legal, responsible way. There are several different types of Creative Commons licence, as you can see here. The CC BY, or the CC attribution licence, is the least restrictive, and the most restrictive licence you can see there at the bottom, which is the CC BY NC ND, and that is the most restrictive of the licences. I'll run through what each element means. So BY, as I've said, stands for attribution. So you must always credit or attribute the creator of the work you wish to use. SA stands for share alike. Share alike licenses allow you to build upon an existing work. You can modify it, adapt it, whatever you whatever you create as a result of those modifications, you have to share them under the same share-alike license. So in other words, you can't modify a BYSA image and then decide to restrict it with a non-commercial license, perhaps, whenever you share it later on. You have to use the same type of license. ND stands for non-derivative. This is in contrast to the share-alike license, and ND licenses prohibit you from making any kind of adaptation. So, for instance, you can't resize an image, you can't remove text from an image, watermarks, logos, that sort of thing. You must use it as you find it. NC stands for non-commercial. So you cannot use and distribute content that you find under this license for any kind of commercial purposes. And finally, you may find content with a public domain Creative Commons license. So if you do, credit the work in the usual way, even though the license may not explicitly state that you must. And this is due to what I was saying earlier, that the UK copyright law differs to other countries. So if in doubt, just credit it. So here's an example of a CC BY attribution license here. It clearly states what the license permits you to do and clearly sets out the terms of use. And clicking on the highlighted text that you'll see there in blue will provide you with further details, and you'll find similar highlighted text going through to different details on the other licenses when you come to them. So always follow the terms of the license that you're using. There was a previous post on our Orb blog recently. This is our dedicated research support blog. And this particular post highlighted some Creative Commons licenses and content, giving some basic examples of where you might find indications that the content you're looking at has been licensed in that way. And it was the link was included to that for a document at the bottom there. That link, I'll share that with you later on, which was a handy guide to the suite of Commons licenses, and it will be sent out to you as well after the session, so you've got it to hand. Is there any quick questions at all about Creative Commons before we move on to the next bit?
There's nothing in the chat so far, Yvette. I want to wait a couple of moments, but it doesn't look like anyone's typing, so I think you can go on.
Okay, thanks, Isabel. Thanks,
I'll
everyone.
take a note if anyone does pop anything in.
Okay, thank you. If anyone has any questions at the end about Creative Commons, then that's fine, we'll cover it then. Thank you. So now we'll go on to where you can find some free and openly accessible content for your presentations. So it's good to be aware that copyright is essentially an economic right. So keep that in mind when using copyrighted work. If you were to do so without permission or acknowledgement, you may cause a negative economic impact on that creator of the work. So if you keep that in mind when you're looking at content, just keep in your mind that, well, if I use it, will it mean that they've lost out financially? That's just a good standpoint to have. Additionally, will your use of the content impact them reputationally? And this is where we'll come to thinking about moral rights. So with this in mind, how can we find openly accessible and free content without impacting negatively upon people? So there are plenty of websites out there that offer openly accessible content free of charge. And we have created a document that lists out some of the more commonly used sites for images and audiovisual content. I will bring up a pod in a moment so you can download the document if you wish, and they'll also be sent out to you at the end of the session. So let me just bring this up. Hopefully you'll see that pod's popped up now. You should be able to download all of those files, but if you have any problems at all, don't worry, because I can send them out at the end of the session. I've also listed here a couple of websites that I found that has usefully compiled some sites that's worth exploring as well. And terms and conditions of use on all of these sites vary quite widely. So please do check the terms of the website you're using and adhere to any licensing terms that you see there. And also, probably quite importantly, you need to make sure that the terms of use are compatible with the work you're producing in your presentation. If you're expected by the conference or workshop organiser to make your presentation available under a CC BY licence, for instance, you will need to make sure that any content you're using also applies that licence. So that's always worth thinking about from the outset, so you know how to restrict your content searches. I'll just hide that copyright files pod just for a moment whilst we move on. As I mentioned earlier, moral rights are an important consideration, and a moral right is an addition to the economic rights we've been speaking about. This is the right to be recognised as an author of a work and a right to the integrity of it. So not only do we need to think about what we use, but also how we use it. So keep in mind, will your use of a third-party work treat the creator in a derogatory way, or will you distort or manipulate the work in such a way that it may cause harm to their reputation? Unless a creator has contractually waived their moral rights to a work, they have a right to complain about any derogatory use. So please keep this in mind, especially if you're dealing with some very sensitive topics in your research and your presentations. It cannot be stressed enough. Please do not use an image directly found from a Google search. Copyrighted and licensed images do find their way there. So if you're unsure where a particular image has come from, TinEye is a great tool to use. It's a reverse image search engine. So it may be useful to bookmark that website if you can, because if you're not sure on the origins of a particular image, it's a good way to check it. Does anyone have any questions before we move on from this section?
There are some questions in the chat box of it.
Okay. You can take an image off Google educational purposes, can't you? You could to a certain extent, but it, like I said earlier, it very much depends on your audience. You need to make sure that the image that you're taking from Google, that you are crediting it properly, that you know the source of it, and that you are using it legitimately. What if you search using the CC filter? Yes, there is that CC filter on Google search, which is a very useful thing to use. I don't know if everybody else is aware of that, but there is a CC filter on Google, but it's not 100% reliable. And from personal experience, it's not something I would rely on entirely. I would still do your due diligence and double check where the image is coming from before using it, particularly if you're using or presenting to external audiences outside of the OU and not for students, because this is something that you need to consider. What about other Google results? Search details, map extracts. I'm guessing you mean not to. It's very, very difficult to see what you're suggesting there, Fiona. I'm guessing it could be if you just need to check the terms and conditions of where you're finding the imagery. It's it's more important for you to make sure that you're crediting the work that you're using properly, rather than just saying, this is a Google image, I'm going to use it as a Google image. It could be from anywhere, and it could be something that you're taking and using not legally. So it's always worth double checking things. I can see your message there, Heather, about images in publications such as blog posts or tweets. There is an example further on in this session that I will show you, and it was taken from a particular blog post query that I have. So I will go through that and let you know. I think we need to just move on a little bit now, I think. Thanks, everyone. And I'll pick up some questions at the end, obviously. So how to obtain permission. So for content that is still under copyright and not openly accessible or licensed under a Creative Commons license or similar, you will need to seek formal permission from the rights holder. So how do we go about this? The first and perhaps most important rule is to send out any permission requests as early as you possibly can. And I can say with experience that some rights holders, particularly publishers, can take weeks and months to respond, and you may have to chase them numerous times for that response. A recent example I can give you is from someone who had recently finished their thesis. They had used around 60 third-party images in their research, so very image heavy, and they were very diligent and contacted rights holders throughout the process to obtain the permission they needed. And even at the end of that process, they were still waiting for some responses and had to redact some images as a result. So contact the rights holder in any way you can, whether that's email, web chat, phone. Keep chasing them until you get that answer that you need, and always get your permission in writing. Never ever rely on verbal agreements to use items. It isn't always easy to find out who to contact for permission. For instance, what if the author of a poem you want to use has died, but it may still be in copyright? So who do you contact? Sometimes the publisher may help you. Sometimes you may have to contact the author's estate, and sometimes you may not be able to get any details at all. Unfortunately, copyright is a very grey area, and you may need to become a bit of a detective to track down that source. I would suggest to keep a log of all the permissions you obtain for future reference. I think that's quite important. So when you do contact them, you need to be very specific and tell them what you want to use and why. And you can see here, this is just a little snippet of an example permission request. This is the sort of request you'd need to send out, not in letter format necessarily like this, but it can be adapted for email or whatever mode of contact you use. And again, a copy of that will be sent to you after the session, so you can get an idea of what you need to ask. So here is an example of what would be considered a substantial use of an item. So text may not be so applicable here if we're thinking about presentations and short presentations, but it is useful to see what you could use here. And these are there are guidelines that the OU uses from the Publishers Association. So a substantial work would be a whole table, chart, a figure, a photograph, a poem, and obviously substantial amounts of text taken from a book or a journal article as well. So these are good guidelines to keep in mind whenever you're using anything. There are some things you don't need to seek permission for. Things like data or information. So there's no copyright in data, but there is, the way it's presented is copyrighted. So for instance, the example there, a data presented in a table format, you could transform it into a graph instead. And all you'd need to do is source the origin of that data, and you wouldn't need to seek permission from anybody. But you will obviously need to seek permission in some cases, to use tables and graphs if you want to use them as they were originally presented. So if you redraw them and they're radically different to the original, you can source the original and state that it's adapted from, as well as source the original source of that data. I can see from a couple of messages there about there might be data protection issues with using data. That's obviously something that you would need to keep in mind, and this session isn't going into a great deal of depth, but just to give you an idea of what you can and can't do, and to make everyone realise that there is a lot of consideration that needs to go into what you want to use for your presentations. There isn't always a straightforward answer to all the queries. But obviously we're here to answer any queries anybody has. If you want to email us with any in-depth questions that you have. And Isabel, she knows a lot about data, obviously. So she'd also be able to help you with that as well. So with all of this in mind, how does this all apply to presentations? So as I was saying, it's quite a grey area, so it really does depend on your context of use, and you would need to consider a few things. So firstly, does the publisher or organiser of the event you're presenting at have a particular requirement? They might about the licenses that you're having your presentation made available under. Check before sourcing any content to ensure that the licenses and terms of use all match up. Is your audience internal to the OU or external? Is there a commercial element to your presentation? Are you planning to share it or record it? So all of these elements are important when considering the kinds of third-party content to use in your presentations. So you really need to think about who will be viewing it now, as well as who might be viewing it in the future. Some examples might be an image found under a CC BY NC license, the non-commercial license. If your presentation is of a commercial nature, an external audience of commercial nature, you would not necessarily be able to use it. Perhaps your presentation includes sensitive content about children or people with a protected characteristic. Should this really be shared externally? These are all the sorts of questions you need to ask yourself as you're choosing the content you want to use. And for instance, you might want to stream a video during your presentation that has very limited rights for internal OU use only. Should the presentation be recorded and shared widely? It's something that you need to think about. And it's important to note here that educational use or educational purposes, as you may sometimes hear, does not apply here. Educational use is very limited in scope, and it only applies to private study and research. For example, in an OU module or a PhD thesis. So if your presentation, your workshop, your conference, whatever you're presenting at, if it falls outside of this, then it's not educational use, and that there are other ways to apply copyright exceptions to what you want to use, and we'll go into that in a moment. So fair dealing, criticism, review and quotation. This is where copyrighted content, including images or video clips, is used in a very specific way and not just for illustration. It has to be very relevant to the work you're presenting and not excessive. So you only have to use what you need to make your point and nothing more. And if the item you want to use meets the criteria listed here, you may not require permission, but it's always best to be cautious. So you can check with us if you're entirely unsure. So as you can see here, it lists limited extracts of works that are published and available to the public. Use only what you need, and it must be acknowledged. And if those criteria are met, then you may be able to use either the criticism or review exception or the quotation exception for some of your presentations. But as I've mentioned earlier, this is all I'm presenting information to you now, but it's all questions that you need to ask as you go through the process, as all of your presentations, workshops, conferences, they will all have very different contexts of use and different expectations. So these are just little things for you to think about and to keep in mind when you're using content. So this is a little example for you. I'm not going to ask you to do anything terrible, but I'll type in the chat here a link to Twitter where this meme was found. If you can, you don't have to, but if you can, click on the link and have a look and see what I've put here. So for the example here, your presentation is on the subject of working from home during COVID lockdown. It might be an external or an internal presentation that you're doing. It was found on Twitter from that user that listed there. And just have a think about it. Do you think you would need permission to use that image? And why are you using it? Just keep those things in mind and have a look at the image and see what you think. I'll just leave it just a couple of moments just to let you have a think about it. Oh, I'm glad you're using TinEye, Fiona. That's good. Okay, so I think that's okay. This was the example that I mentioned a little bit earlier, where someone wanted to actually use this in one of their blog posts. So what we did is we Google searched it, we used TinEye, and we came back unable to source the original creator of that meme. It was widely publicly available, and therefore we don't know who to go to permission for that. So in context of what the blog post was, or in this case, this example of the presentation, just using one image like this isn't excessive. It's relevant to what our presentation is about, and we could apply the fair dealing quotation exception here, but we must credit where we found it. I know that it's the Muppets image, and this is the one of the queries that we had, and this went to our intellectual property team as well as it coming through me. And because it fits all of this criteria, we can use that copyright exception rule there. Memes are quite complicated. And just another quick example here, because I know that we're running out of time a little bit. I might just talk you through this instead rather than giving you the link to have a look at. But this was another example that I came across, a video about the Cornish language, and the person wanted to use it and wasn't quite sure whether they could. So could we use it, and why are we using it? Well, the why are we using it is probably not so relevant here, because we can see on the YouTube page under the WikiTongues channel that they have applied a CC BY attribution license to it. So if you make sure that you can check the details on any YouTube pages, description pages, sometimes you may find that these videos are licensed in that way. And YouTube also gives you the opportunity, a bit like Google almost, you can filter items by a Creative Commons license. So you can easily find relevant content under that license, and you need not worry, and you can use it exactly how you want to use it. So the overall message I want to get out today is to really apply a common sense and cautious approach to what you want to do and what you want to use. Think through your choices in a logical way and use only what you need to make your point, but also to be aware that if there is something you desperately want to use, but you're unsure if it's possible, you can let us know and we can work through the process with you once we know what you want to use, how and why. And if you're ever in any doubt, contact us for advice. So just further along here, we've got some useful links and information for you. This is our research support page where you'll find a whole host of information and advice. There's some useful links here about copyright. Stephanie, you can contact us here in the library research support team and we can check any requests that you have. You can subscribe to our org blog to keep up to date with what we're doing, and we run other training sessions as well. There's other sessions on copyright, but that's more to do with the thesis side of things. And you can email us, use the online contact form, and just get in touch whenever you come across any copyright issues that you might have. And if it's something that requires a little bit more of a legal viewpoint, then we can collaborate with our intellectual property team, which are also based in the library, and we'll be able to work it through for you. So I know we're very limited on time here, but I can take a couple of questions before we go. And also, if you wouldn't mind, please do fill out our form today. Just let us know how you found the session, and let us know what you liked, what you might change. It's all very useful, and we do appreciate everybody doing that for us, if you wouldn't mind.
Yvette, do you want me to give you a couple of the questions that came up earlier while we wait to see if anyone types anything in? Okay, there was a question, and I expect this is to do with copyright of materials that are produced while you're working for an institution. Someone's asked, what happens if you're affiliated to more than one institution? Do you have any idea on that?
Oh, that's a good question. I'm unsure, to be honest with you, and it's not something that I've come across before. It might be that both institutions work in a very similar way. They have very similar terms that you would have to abide by. It's probably worth checking with both organisations and see what they say. I'm sorry I can't be more helpful than that, but it might be something that I can find out just for from a general point of view, to see whether it's something that you'd have to have some kind of agreement between the two, or if you'd have to go with one particular organisation's way of working things. So I will find out, and I'll post it perhaps on the Teams area sometime if I get an answer. So that's a good question. Thank you.
Okay, here's another question which you briefly touched on, but I don't think you fully understood what the question was. So it's about using screenshots of results on Google, particularly Google Maps, and whether that holds copyright, whether a screenshot of a map on Google holds copyright.
Oh, a screenshot?
Yeah.
Okay. If you're taking screenshots from a Google page, like you say, I should think crediting it as a screenshot from Google might be okay, but it depends on the kind of content that you're looking at. I would still probably abide by whatever terms were related to the websites that you're perhaps showing within the screenshot, or whatever image may be there. It's one of those things that you can't really give an answer to unless you see it, if you see what I mean. So if you ever do come across anything like that, just run it past us and we'll be able to let you know. But it's such an odd area, copyright. It's always best to be able to see and visualize and know what you're trying to do to be able to give you an answer. I hope that helps a little.
It's so difficult, isn't it? Okay, I'll give you one more question and then probably we ought to finish. So there's a question about Twitter terms and conditions and whether the Twitter terms and conditions make any difference to copyright in tweets.
It is a copyrighted work. Whatever Twitter post it is a copyrighted work. Hence, the example I gave earlier with the Muppets meme. It still needed to be acknowledged to that person wherever you found it. So, yes, Twitter terms and conditions aren't the easiest to go through and process. I understand that. But I do have some information somewhere about how to use social media content, and that's something I can also post up on the team's site for everybody to view as well at some point in the near future, if that would be helpful to everybody. Again, it's one of those things, if you're using content like that, it very much depends on the context of your use, why you want to use it, and making sure that things are properly credited. So yeah, it's just a funny old area, copyright, I'm afraid. But as I say, we're always on hand to answer your queries if we have the background information of what you're using and why, then we can help you, no problem at all.
Okay, do you want to leave it there? There are a couple of questions that haven't been addressed, but I suppose people can always email us with their questions. We can get back to them. That might be better than...
And when I email out the documents to everybody, I can pick up those questions that went unanswered and I can put that in an email to you as well, so everybody will have the answer to that. I hope that's okay for everybody. Thanks ever so much for coming today. I really appreciate it. And I know copyright is such a wide area and there aren't any easy answers, but I really do appreciate you coming along today and just giving it a go and having a think about everything. So thank you. Thanks everyone. I appreciate it.